Good afternoon to everybody. Registrar, would you please call the case?
Good afternoon, Your Honor. This is case number IT 0588/2A, the prosecutor versus Mr. Tolimir.
Thank you. Mr. Tolimir, can you hear the proceedings in a language you understand?
Yes, Godspeed to everybody. I can follow the proceedings in Serbian. Thank you.
Tolimir, I will now ask for the appearances by the parties. First, Mr. Tolimir.
Thank you, Gospodin President.
Thank you, Mr. Presiding Judge. My name is Zdravko Tolimir, and in front of me is Dr. Alexander Gajic, my legal advisor. Thank you.
Prosecution.
Good afternoon, Mr. President, Your Honors. Kyle Wood for the prosecutor, along with Todd Schneider, Nima Milaninia, and Lada Shulyan, along with our case manager, Janet Stewart.
Thank you, Mr. Wood. As the registrar announced, the case on our agenda today is prosecutor against Zdravko Tolimir. In accordance with the scheduling order issued on 24th of March 2015, today the appeals chamber will deliver its judgment. At the outset, I would like to inform the parties that Judge Patrick Robinson is unable to sit during this hearing. The appeals chamber, therefore, will conduct this hearing pursuant to Rule 15 bis of the Rules of Procedure and Evidence in the absence of Judge Robinson. Following the practice of the tribunal, I will not read out the text of the appeal judgment, except for the disposition, but instead will summarize essential issues on appeal and the central findings of the appeals chamber. This oral summary does not constitute any part of the official and authoritative judgment of the appeals chamber, which is rendered in writing and will be distributed to the parties at the close of the hearing. This appeal concerns the responsibility of Mr. Tolimir for crimes committed in the Srebrenica and Zepa enclaves in eastern Bosnia in 1995. At the time, Mr. Tolimir was an assistant commander and the chief of the sector for intelligence and security affairs of the main staff of the Army of the Republika Srpska. I will refer to the Army of the Republika Srpska as the VRS. The trial chamber, Judge Niyambe dissenting, found that Tolimir participated in two joint criminal enterprises alleged in the indictment. A joint criminal enterprise to murder the able-bodied men of Srebrenica, and a joint criminal enterprise to forcibly remove the Bosnian Muslim population from the Srebrenica and Zepa enclaves. The trial chamber, Judge Niyambe dissenting, found Tolimir guilty pursuant to Article 7.1 of the Statute of the Tribunal of genocide, conspiracy to commit genocide, extermination, murder, persecutions, and inhumane acts through forcible transfer. The trial chamber, Judge Niyambe dissenting, sentenced Mr. Tolimir to life imprisonment. Mr. Tolimir submits 25 grounds of appeal challenging his convictions and his sentence. He requests that the appeals chamber reverse all of his convictions or, in the alternative, significantly reduce his sentence. The appeals chamber will now address each of Mr. Tolimir's contentions. In grounds of appeal 1 through 4, Mr. Tolimir challenges the trial chamber's decision to take judicial notice of adjudicated facts and its evaluation of certain evidence. For reasons given in its judgment, the appeals chamber, Judge Antonetti dissenting, finds that the trial chamber did not err in taking judicial notice of 523 adjudicated facts from other ICTY trial and appeal judgments, and it did not err in its assessment of these facts. The appeals chamber, Judge Antonetti dissenting, dismisses Tolimir's ground of appeal 1. Mr. Tolimir also challenges the trial chamber's reliance on intercepted communications produced by the Bosnian Muslim side to the conflict. He submits that in reaching its conclusions on the intercepted communications, the trial chamber made a number of errors which invalidate the trial judgment. For reasons set out in the judgment, the appeals chamber finds that the trial chamber did not err in its assessment of the intercepted communications. The appeals chamber therefore dismisses Tolimir's ground of appeal 2. Under its ground of appeal 3, Mr. Tolimir submits that the trial chamber erred in law by accepting Richard Butler as an expert witness. He argues that the prosecution failed to disclose his expert report as required by Rule 94b of the Rules of Procedure and Evidence, and that Butler's long-standing association with the Office of the Prosecutor should have led the trial chamber to characterize Butler as an OTP investigator giving evidence of his personal opinion. For reasons given in the written judgment, the appeals chamber finds that the trial chamber erred in considering that the prosecution's notice of its intention to call Butler as an expert witness sufficed to meet the requirements of Rule 94b. The appeals chamber also finds that the trial chamber erred in finding that Mr. Tolimir implicitly accepted Butler's expert status during the trial. The appeals chamber concludes, however, that these trial chamber's errors caused no prejudice to Mr. Tolimir or had any impact on his conviction. The appeals chamber, Judge Antonetti dissenting, further finds that for reasons given in the judgment, the trial chamber did not err in regarding Butler as an expert witness or in the manner in which it evaluated his evidence. The appeals chamber, Judge Antonetti dissenting, therefore dismisses Tolimir's ground of appeal 3. Tolimir further challenges, under his ground of appeal 4, the trial chamber's assessment of the evidence of 6 prosecution witnesses who are current or former prosecution investigators. For reasons given in the judgment, the appeals chamber finds that the trial chamber applied the correct legal standard when assessing the evidence of these witnesses, and that it acted within its discretion in determining the weight to be given to their evidence. Accordingly, the appeals chamber dismisses Tolimir's ground of appeal 4. In grounds of appeal 6 through 13, Mr. Tolimir challenges some of the trial chamber's legal and factual findings regarding extermination as a crime against humanity, genocide, and forcible transfer. Under his ground of Appeal 9, Tolimir makes a number of challenges to the trial chamber's calculation of the number of persons unlawfully killed by Bosnian Serb forces after the fall of Srebrenica. First, he asserts that the trial chamber erred in law in calculating the number of persons killed in circumstances other than the incidents specified in the indictment. Second, he asserts that the trial chamber committed methodological errors in calculating the total number of those killed. Third, he challenges the trial chamber's findings in calculating the number of victims unlawfully killed in 4 specific incidents. I will return to ground 6 and 9 in a moment. The trial chamber found that at least 5,749 Bosnian Muslims were unlawfully killed by the Bosnian Serb forces following the fall of Srebrenica. This number included those killed at the specific crime sites cited in paragraphs 21.1 through 22.4 of the indictment, and 779 individuals killed in circumstances not specified in the indictment. The appeals chamber emphasizes that in reaching its judgment, a trial chamber can only convict an accused of crimes which are charged in the indictment. Material facts not pleaded in the indictment cannot serve as a legitimate foundation for a conviction against the accused. In the present case, the incidents charged in the indictment are not mere examples of criminal conduct for which Tolimir is alleged to be responsible, but an exhaustive list of specific allegations charged against him. The appeals chamber therefore finds that the trial chamber erred by finding that 779 persons were unlawfully killed by Bosnian Serb forces in circumstances not specified in the indictment, and by relying on this higher number in support of its conclusions on Mr. Tolimir's convictions. The appeals chamber is not satisfied, however, that this error of law invalidates the trial judgment, as Mr. Tolimir fails to show why his convictions should not stand on the basis of the number of individuals the trial chamber found were unlawfully killed in the specific circumstances of the indictment. With respect to Mr. Tolimir's contention that the trial chamber committed methodological errors in calculating the total number of those killed, the appeals chamber observes that the trial chamber reached its findings on the number of individuals killed in the incidents specified in the indictment by analyzing a combination of evidence comprising witness testimony as to the circumstances of the killings, forensic evidence, and demographic data. For reasons detailed in the judgment, the appeals chamber rejects Mr. Tolimir's challenges to the trial chamber's findings that persons identified from Srebrenica-related mass graves were killed unlawfully. Similarly, for reasons given in the judgment, The appeals chamber dismisses Mr. Tolimir's arguments challenging the reliability of the demographic and DNA-based evidence relied upon by the trial chamber. The appeals chamber also finds that the trial chamber did not err in calculating the number of Bosnian Muslims killed at 4 incidents specified in the indictment, as alleged by Mr. Tolimir. Accordingly, the appeals chamber dismisses Tolimir's ground of appeal 9. Under ground of appeal 6, Mr. Tolimir challenges his conviction for extermination. His principal argument is that the trial chamber erred in law by applying an incorrect legal standard concerning the mens rea for extermination as a crime against humanity, arguing that the victims of this crime must have been targeted on the basis of their civilian status. Tolimir further submits that the trial chamber erred in finding that the killings of Mr. Mehmet Hadžić, Zepa's mayor and president of the war presidency, Colonel Avdo Palić, commander of the Army of Bosnia and Herzegovina Zepa Brigade, based in Zepa, and Mr. Amir Imamović, the head of the Civil Protection Unit. These are, I will refer to these three as 3 Zepa leaders, were part of a single murder operation since they were killed in a period after the murder operation in Srebrenica. The appeals chamber recalls that while the establishment of the actus reus of a crime against humanity requires that the crime occur as part of a widespread or systematic attack directed against a civilian population, the victims of the underlying crime do not have to be civilians. The appeals chamber thus rejects Mr. Tolimir's argument that the trial chamber applied an incorrect mens rea standard. With regard to Tolimir's argument that the killings of the 3 Zepa leaders was not part of the one murder operation involving the mass killings of the men of Srebrenica, the appeals chamber recalls that the actus reus of the crime of extermination is, and I quote, the act of killing on a large scale, unquote, and the mens rea is the intention to kill on a large scale. The assessment of large scale is made on a case-by-case basis, taking into account the circumstances in which the killings occurred, while the actus reus of the crime of extermination may be established through an aggregation of separate incidents. The appeals chamber has held that, and I quote, the element of killing on a large scale cannot be satisfied by a collective consideration of distinct events committed in different prefectures in different circumstances by different perpetrators and over an extended period of time, that is, a period of 2 months. The appeals chamber observes that the trial chamber found that there are factors shared by the murders of the 3 Zepa leaders with the mass murders of the men and boys of Srebrenica. These are the fact that the murders occurred in the weeks following the fall of the 2 enclaves, the fact that the victims were all Bosnian Muslims, the violence of the killings, the general identity of the perpetrators of the killings as members of the Bosnian Serb forces, and the link to the overall goal of the Bosnian Serb forces of, quote, ridding the enclaves of its Bosnian Muslim population, unquote. The appeals chamber notes, however, that the trial chamber found that the three Zepa leaders were killed in late August and September. Therefore, after the main attack against the civilian population, which lasted until the end of July 1995, and included the military operations against both enclaves, the removal of thousands of civilians from Srebrenica and Zepa, and the killings of the Bosnian Muslim men from Srebrenica. At the time of the killing of the three Zepa leaders, both enclaves were empty, and the civilian population had been transferred to Army of Bosnia and Herzegovina held territory. Further, the appeals chamber notes that the murder of the three Zepa leaders was charged in the indictment and found by the trial chamber to be a foreseeable consequence of the JCE to forcibly remove and not the JCE to murder. The appeals chamber additionally observes that prior to the killings, the three Zepa leaders were singled out from the other Bosnian Muslim male prisoners who were not killed, but were to be ultimately subject to a prisoner exchange agreement. Consequently, the appeals chamber is not convinced that the killing of the three Zepa leaders was part of the same murder operation that had targeted the men and boys of Srebrenica. For these reasons, the appeals chamber upholds ground of Appeal 6 in part to the extent that it concerns the killings of the three Zepa leaders and dismisses the remainder of the ground. Under its ground of Appeal 13, Tolimir challenges the trial chamber's findings that the busing of Bosnian Muslims out of Potocari on 12 and 13 July 1995 and out of Zepa on 25-27 July 1995 constituted the crime of forcible transfer. He contends that the trial chamber erred in finding that the transfer of the population was forced, since it was the Bosnian Muslim authorities in Sarajevo and Zepa that sought to evacuate the civilian population of Srebrenica and Zepa before the attacks on the two enclaves occurred. He also submits that the trial chamber failed to provide a reasoned opinion by not explaining that the civilian populations of Srebrenica and Zepa were displaced within a national border, arguing that since the border between the Republika Srpska and Bosnia and Herzegovina was a de jure or de facto border, the transfer of the populations across that border could not constitute the crime of forcible transfer. In finding that the population transfers from the Srebrenica and Zepa enclaves were forced, the trial chamber cited the well-settled principle of international humanitarian law that forced displacement is not justified in circumstances where the humanitarian crisis that caused the displacement is itself the result of the accused's unlawful activity. For reasons given in the judgment, the appeals chamber finds no error in the trial chamber's assessment of the evidence and in its conclusion that the transfer of the population from the Srebrenica and Zepa enclaves was forced. The appeals chamber also finds that the trial chamber did not fail to provide a reasoned opinion as submitted by Mr. Tolimir. The trial chamber reasonably found that the civilians were forcibly displaced to other areas of Bosnia and Herzegovina, for example, Kladanj, which did not constitute an area across a de jure or de facto border. Although the trial chamber did not make an express finding that the civilian populations of Srebrenica and Zepa were displaced within national boundaries, it is clear that the trial chamber found that the civilian populations were transferred to areas within the national boundaries of Bosnia and Herzegovina. For these reasons, the appeals chamber, Judge Antonetti dissenting, dismisses ground of appeal 13. Under grounds of appeal 8, 10, 11, and 12, Mr. Tolimir makes a number of challenges to the trial chamber's legal and factual findings regarding the crime of genocide. The trial chamber found Mr. Tolimir guilty of genocide committed through the killings of the men from Srebrenica, through causing serious bodily or mental harm to the men from Srebrenica and the women, children, and elderly from Srebrenica and Zepa, and through inflicting on the protected group conditions of life calculated to bring about their destruction. Mr. Tolimir first submits that the trial chamber erred in law in finding that the Bosnian Muslims of eastern Bosnia and Herzegovina qualified as part of a protected group under Article 4 of the statute, ground of appeal 8. Second, he argues that the trial chamber erred in law and fact in its analysis of the actus reus of genocide by 1. Misinterpreting serious mental harm as an underlying genocidal act and applying that erroneous interpretation to the facts of the case, grounds of appeal 7 in part and 10 in part. And 2. Misinterpreting the term, quote, physical destruction, unquote, under Article 4.2c of the statute, ground of appeal 10 in part. Third, Mr. Tolimir submits that the trial chamber erred in law in its analysis of the mens rea required for genocide, grounds of appeal 7 in part, 11 and 12. For reasons set out in the judgment, the appeals chamber finds no merit in Mr. Tolimir's contention that the trial chamber erred in law by failing to provide a reasoned opinion as to why the Bosnian Muslims qualified as a protected group under Article 4 of the statute, and why the Bosnian Muslims of eastern Bosnia and Herzegovina were a substantial part of that group. In reaching its conclusion on this point, the trial chamber referred to and applied by analogy the reasoning given in the Popovic Italia trial judgment and in the Kerstich appeal judgment as to why the Bosnian Muslim population of Srebrenica, although a small percentage of the overall Muslim population of Bosnia and Herzegovina amounted to a substantial part of that group. The trial chamber thus held that the reasoning in other relevant cases equally applied to the population specified in the indictment, namely the Bosnian Muslim population in the enclaves of Srebrenica, Zepa, and Gorazde. The appeals chamber finds no error with this approach. The appeals chamber therefore dismisses Tolimir's ground of appeal 8. The appeals chamber likewise finds no merit in Mr. Tolimir's arguments that the trial chamber erred in law and fact in finding that Bosnian Serb forces inflicted serious bodily or mental harm as defined in Article 42b of the statute on the Bosnian Muslim males from Srebrenica. The appeals chamber recalls that, quote, threats of death, unquote, and knowledge of impending death have been accepted as amounting to serious mental harm under Article 4 of the statute. Further, there is nothing in the statute or in the Genocide Convention that prevents a trial chamber from considering the harm suffered by a victim prior to death as a separate acta reus of genocide. Further, the appeals chamber finds no error in the trial chamber's conclusion that the forcible transfer of the Bosnian Muslim population out of Srebrenica amounted to infliction of serious mental harm, and thus an act of genocide under Article 4b of the statute. Nothing in the tribunal's jurisprudence or the Genocide Convention supports Mr. Tolimir's contention that forcible transfer may only constitute genocide if the displaced population is transferred to concentration camps or places of execution. Considering the trial chamber's findings regarding the painful separation process of the women, children and elderly from their male family members in Srebrenica, the fear and uncertainty as to their fate and the fate of their detained male relatives and the appalling conditions of their journey to Army of Bosnia and Herzegovina held territories, the appeals chamber is satisfied that the trial chamber provided sufficient reasoning for its conclusion that the suffering of the women, children, and elderly forcibly transferred out of Srebrenica inflicted serious mental harm and thus constituted an act of genocide under Article 4.2b. Further, for reasons set out in the judgment, the appeals chamber, Judge Antonetti dissenting, also dismisses Mr. Tolimir's contention that the trial chamber erred in law and fact in finding that the Bosnian Serb forces who committed the underlying acts set out in Article 4.2a through c had genocidal intent. With respect to Mr. Tolimir's challenges to the trial chamber's findings regarding the serious bodily or mental harm inflicted on the Bosnian Muslim population forcibly transferred from Zepa, the appeals chamber recalls that under the Genocide Convention, serious mental harm results only from acts causing grave and long-term disadvantage to the ability of members of the protected group to lead a normal and constructive life, and threatening the physical destruction of the group as such. The appeals chamber notes that, unlike the Bosnian Muslims forcibly transferred from Srebrenica, the trial chamber made no findings and cited no evidence as to the lasting impact of the forcible transfer operation on Zepa's population. The appeals chamber further recalls that acts falling under Article 42b of the statute require proof of a result, that is, that serious mental harm was inflicted. The appeals chamber, Judge Sekule and Judge Gunay dissenting, finds that in the absence of findings or reference to evidence of any long-term consequences of the forcible transfer operation on the Zepa population and the Bosnian Muslim population of eastern Bosnia and Herzegovina in general, and of a link between the circumstances of the transfer operation in Zepa and the physical destruction of the protected group as a whole, no reasonable trier of facts could have found that the Bosnian Muslims forcibly transferred from Zepa suffered serious mental harm within the meaning of Article 42b of the statute. Accordingly, the appeals chamber, Judge Sekule and Judge Gunay dissenting, grants ground of appeal 10 in part and reverses Tolimir's conviction for genocide through causing serious mental harm to the Bosnian Muslim population of eastern Bosnia and Herzegovina under Article 42b of the statute, to the extent that this conviction was based on the Bosnian Serb operations in Zepa. This conclusion does not amount to a conclusion that the Bosnian Muslims of Zepa were not the victims of genocide. The appeals chamber emphasizes that the only question addressed here is whether the trial chamber erred in finding that the forcible transfer operation in Zepa inflicted on the transferred Muslim population serious mental harm, as this term is defined in Article 42b of the statute. The appeals chamber recalls here its earlier conclusion that the trial chamber did not err in finding that the Bosnian Muslims of Zepa were within the targeted part of the protected group and were thus among the ultimate victims of the genocidal enterprise against the Muslims of eastern Bosnia and Herzegovina. Tolimir further challenges the trial chamber's finding that the conditions resulting from the combined effect of the forcible transfer operations of the women and children and the killing of the Bosnian Muslim men were deliberately inflicted and calculated to lead to the physical destruction of the Bosnian Muslim population of eastern Bosnia and Herzegovina. The appeals chamber has not previously been called upon to address the issue of what acts qualify as the actus reus of genocide under Article 42c of the statute. However, it is satisfied that the legal principles stated by the trial chamber are consistent with the existing case law of the ICTY and the ICTR, as well as the letter and spirit of the Genocide Convention. The appeals chamber finds that the deliberate infliction on the protected group of conditions of life calculated to bring about its physical destruction in whole or in part covers methods of physical destruction other than killing, whereby the perpetrator ultimately seeks the death of the members of the group. Such methods of destruction include deprivation of food, medical care, shelter or clothing, as well as lack of hygiene, systematic expulsion from homes, or exhaustion as a result of excessive work or physical exertion. The trial chamber considered the combined effect of 1. The forcible transfer operation in relation to Srebrenica's Muslim women, children, and elderly from Potocari, and Zepa's Muslim population, and 2. The killing of at least 5,749 Bosnian Muslim men from Srebrenica, to conclude that these operations were aimed at destroying this Bosnian Muslim community and preventing reconstitution of the group in this area, that is, eastern Bosnia and Herzegovina. In the view of the appeals chamber, the trial chamber's aggregation of the killings and the forcible transfer operations under Article 4.2c of the statute was an error, as it contravened the very case law cited by the trial chamber in paragraph 740 of its judgment. The appeals chamber recalls that Article 4.2c of the statute covers methods of destruction that do not immediately kill the members of the group, but ultimately seek their physical destruction. The appeals chamber therefore accepts Tolimir's argument that the trial chamber was legally barred from considering the combined effect of the killing and the forcible transfer operations under Article 4.2c of the statute. The appeals chamber further notes that in its application of Article 4.2c of the statute, the trial chamber considered the destruction of mosques in Srebrenica and Zepa as an additional act through which the Bosnian Serb forces inflicted on the protected group conditions of life calculated to bring about its destruction. As the trial chamber itself acknowledged, acts amounting to cultural genocide are excluded from the scope of the Genocide Convention. The trial chamber therefore committed a legal error in considering the destruction of mosques in Srebrenica and Zepa under Article 4.2c of the statute. In light of the legal errors identified above, the appeals chamber will proceed to examine the factual findings of the trial chamber and the evidence on the record in order to determine whether the forcible transfer operations of the Muslim populations of Srebrenica and Zepa, excluding the killings of Srebrenica's males and the destruction of mosques in the enclaves, were conducted under such circumstances as to impose on the protected group conditions of life meeting the threshold of Article 4.2c of the statute. In this regard, the appeals chamber recalls its holding in the Kerstic case that a forcible transfer operation does not amount to physical destruction as such, and the displacement of a protected group either in whole or in part, does not constitute a genocidal act per se. After carefully examining the relevant evidence, the appeals chamber is not convinced that the forcible transfer operations Srebrenica and Zepa, viewed separately from the killings of Srebrenica's male population, were conducted under circumstances calculated to result in the total or partial physical destruction of the protected group, that is, the Muslims of eastern Bosnia and Herzegovina. The trial record is devoid of evidence that the forcible transfers, if they are analyzed separately from the killing operation and the destruction of mosques in Srebrenica and Zepa, were carried out with a view to the destruction of the group as distinct from its removal from the region. Although the appeals chamber is satisfied that there was a deliberate plan to expel the Bosnian Muslim women, children, and elderly from Srebrenica and the entire Muslim population from Zepa, the appeals chamber finds that it has not been established beyond reasonable doubt that such a policy of removal implemented through the JCE to forcibly remove was aimed at causing the physical destruction of these populations. The appeals chamber emphasizes that this conclusion does not amount to a conclusion that the Bosnian Muslims of Zepa were not the victims of genocide. The appeals chamber has confirmed the trial chamber's finding that the Bosnian Muslims of Zepa are, along with the Muslims of Srebrenica and eastern Bosnia and Herzegovina in general, members of the protected group within the meaning of Article 4 of the statute, and were thus among the ultimate victims of the genocidal enterprise against the Muslims of eastern Bosnia and Herzegovina. Accordingly, the appeals chamber grants Mr. Tolimir's ground of appeal 10 in part to the extent that it challenges the trial chamber's findings under Article 4.2c of the statute for infliction of conditions calculated to destroy the protected group, and reverses Tolimir's conviction for genocide under Article 4.2c of the statute. Mr. Tolimir further challenges the trial chamber's conclusion that the Bosnian Serb forces killed the 3 Zepa leaders with the intent of destroying the Muslim population of eastern Bosnia and Herzegovina as such. The appeals chamber agrees with the trial chamber that the selective targeting of leading figures of a community may amount to genocide and may be indicative of genocidal intent. For a finding of genocide, it suffices that the leaders were selected for the impact that their disappearance would have on the survival of the group as such. The trial chamber found that all 3 Zepa leaders were arrested and detained shortly after the completion of the forcible removal operation in Zepa at the end of July 1995, and that Hadžić and Imamović were killed sometime in late August 1995, while Palić was killed in early September 1995. It is clear from these findings that the killings did not precede or occur simultaneously with, but followed the forcible transfer of the Zepa population. The appeals chamber recalls that the character of the attack on the leadership must be viewed in the context of the fate or what happened to the rest of the group at the same time or in the wake of that attack. The trial judgment contains no findings or reference to evidence as to the impact of the disappearance of the 3 Zepa leaders on the survival of the Bosnian Muslim populations from Zepa. The trial chamber failed to explain how their detention and killings, committed weeks after the entire Zepa population had been forcibly transferred from the enclave, had any impact, and I quote, on the survival of the group as such, unquote. In light of the fact that the forcible transfer operation of Zepa's Bosnian Muslims had been completed before the 3 Zepa leaders were detained and killed, and in the absence of any findings as to whether or how the loss of these 3 prominent figures affected the ability of the Bosnian Muslims from Zepa to survive in the post-transfer period, the inference of genocidal intent was not the only reasonable inference that could be drawn from the record. The appeals chamber therefore finds that the trial chamber erred in holding that the 3 Zepa leaders were killed by the Bosnian Serb forces with the specific intent of destroying part of the Bosnian Muslim population as such, and grants Mr. Tolimir's ground of appeal 12. In grounds of appeal 5 and 14 through 20, Mr. Tolimir contests the trial chamber's legal and factual findings concerning his responsibility for participation in the 2 joint criminal enterprises, the joint criminal enterprise to murder and the joint criminal enterprise to forcibly remove. Mr. Tolimir first challenges, under ground of appeal 5, the trial chamber's finding that JCE is a mode of liability under customary international law. For reasons set out in the judgment, the appeals chamber, Judge Antonetti dissenting, finds no merit in Mr. Tolimir's submissions and dismisses his ground of appeal 5. The appeals chamber, Judge Antonetti dissenting, also finds no merit in Mr. Tolimir's submissions that the trial chamber erred in law and fact in making findings on the relevant VRS military principles and on his position as Assistant Commander and Chief of the Sector for Intelligence and Security Affairs. The trial chamber reasonably found that pursuant to the regular military chain of command, the security organs were directly subordinated to the commander of those brigades or units for their day-to-day work, and that the chief of the sector for intelligence and security affairs directed, coordinated, and supervised the work of subordinate security and intelligence organs with respect to matters associated with security or intelligence. The appeals chamber further confirms the trial chamber findings in relation to Mr. Tolimir's powers and the information available to him. Therefore, the appeals chamber, Judge Antonetti dissenting, dismisses Mr. Tolimir's ground of appeal 14. Under his ground of appeal 15, Mr. Tolimir challenges the trial chamber's conclusion that a JCE to forcibly remove existed and its conclusions about his participation in it. Specifically, he argues that the trial chamber erred in 1. Finding that the RS leadership adopted objectives in May 1992 which evidenced the policy to get rid of Muslim population of eastern Bosnia and Herzegovina, misinterpreting Director 7 and its relationship with Director 7/1 and consequent VRS military orders. 2. Finding that the VRS participated in the restrictions of UNPROFOR and humanitarian aid convoys. 3. Taking into consideration an attack on the Srebrenica enclave through a tunnel in the night of 23 to 24 June 1995. And 4. Finding that the enclave's status as safe areas was inviolable under international law, even though they were not fully demilitarized. For reasons set out in the judgment, the appeals chamber, Judge Antonetti dissenting, finds no merit in Mr. Tolimir's submissions. Similarly, the appeals chamber, Judge Antonetti dissenting, finds no support for Mr. Tolimir's argument that the trial chamber erred in fact and in law in finding that he significantly contributed to the JCE to forcibly remove. With respect to his liability, pursuant to the JCE to murder, Tolimir first contends that the trial chamber erred in fact and law in finding the two killing incidents, namely the killings at Kravica warehouse of 600 to 1,000 Bosnian Muslims on 13 and 14 July 1995, and the killings of 6 Bosnian Muslims from Srebrenica by the Scorpions unit at a site near Trnovo were executed to achieve the common purpose of the JCE to murder. For reasons set out in the judgment, the appeals chamber, Judge Antonetti dissenting, finds no error in the trial chamber's findings that the killings at Kravica warehouse were part of the common part to murder and dismisses Mr. Tolimir's ground of appeal 19. With respect to Mr. Tolimir's challenges to the trial chamber's conclusions regarding the killings of 6 Bosnian Muslims from near Trnovo, the appeals chamber notes that the trial chamber did not explicitly find that there existed a link between the members of the Scorpions unit who committed the Trnovo killings and a member of the JCE, and that, therefore, the killings formed part of the JCE to murder. The trial chamber only alluded to such a finding by concluding on the basis of the, quote, evidence in its totality, unquote, including evidence of the Trnovo killings, that a common plan to murder the Bosnian Muslim males from Srebrenica existed. The appeals chamber finds that the trial chamber's failure to further elaborate on the required link between the perpetrators and a JCE member amounts to a failure to provide a reasoned opinion. In view of the trial chamber's error of law, the appeals chamber will consider whether the factual findings in the trial judgment on a whole would allow a reasonable trial of fact to establish a link between the Scorpions unit and a member of the JCE to murder. The appeals chamber notes that even though the trial chamber found that the Scorpions unit was acting at the relevant time under the direction of the Bosnian Serb forces, it failed to identify under whose direction or pursuant to whose orders they acted. The appeal chamber recalls that the trial chamber did not find that all the members of the Bosnian Serb forces were also members of the JC to murder, while the evidence upon which the trial chamber relied suggests that the 6 men were transported from the Srebrenica area to Trnovo by members of the Scorpions unit, where they were subsequently killed. The appeals chamber is not convinced that it was reasonable for the trial chamber to infer from these facts that the Scorpions unit perpetrated the 6 killings in Trnovo in furtherance of the common plan of the JCE to murder. The appeals chamber therefore grants Mr. Tolimir's ground of appeal 20. Under his ground of appeal 16, Mr. Tolimir challenges the trial chamber's conclusions that he was aware of and intended the common plan to murder the able-bodied Bosnian Muslim men from the Srebrenica enclave. He also challenges the trial chamber's findings that he significantly contributed to this common plan. For reasons set out in detail in the judgment, the appeals chamber, Judge Antonetti dissenting, rejects Mr. Tolimir's arguments that the trial chamber's conclusions regarding his knowledge and contribution to the JCE was primarily based on his position as assistant commander, and that the trial chamber incorrectly interpreted prosecution and defense exhibits relevant to his participation in the JCE to murder. The appeals chamber, Judge Antonetti dissenting, dismisses Mr. Tolimir's ground of appeal 16. Under grounds of appeal 17 and 18 of his appeal, Mr. Tolimir challenges the trial chamber's findings on his responsibility pursuant to JC 3 for persecutory acts, including opportunistic killings, as a natural and foreseeable consequence of JC to forcibly remove and JC to murder, ground 17, and for the killings of the 3 Zepa leaders as a natural and foreseeable consequence of the JC to forcibly removed, ground 18. For reasons set out in the judgment, the appeals chamber, Judge Antonetti dissenting, finds no merit in Mr. Tolimir's arguments and dismisses his grounds of appeal 17 and 18. In grounds of appeal 21 through 23, Mr. Tolimir challenges the trial chamber's findings regarding his responsibility in relation to genocide, conspiracy to commit genocide, and crimes against humanity. For reasons given in the judgment, the appeals chamber, Judge Antonetti dissenting, finds that the trial chamber did not err in finding that Mr. Tolimir possessed genocidal intent and that he possessed the mens rea required for crimes against humanity. The appeals chamber, Judge Antonetti dissenting, also confirms the trial chamber's findings that Mr. Tolimir was criminally responsible for conspiracy to commit genocide on the basis of his significant contribution to the JCE to murder, The Appeals Chamber, Judge Antonetti dissenting, therefore dismisses Mr. Tolimir's grounds of appeal 21 through 23. Finally, in ground of appeal 24, Mr. Tolimir contests the trial chamber's findings on his cumulative convictions, and in ground of appeal 25, its findings in relation to his sentence. For reasons set out in the judgment, the appeal chamber finds that the trial chamber did not err in law or in fact in applying the principles of cumulative convictions, and dismisses Mr. Tolimir's ground of appeal 24. The appeals chamber, Judge Antonetti dissenting, also finds that the trial chamber did not err in applying the principles of sentencing by imposing a sentence that is manifestly excessive and disproportionate. I now turn to the impact of the appeals chamber's findings on the sentencing. In this context, the appeals chamber recalls that it reversed some of the convictions of Mr. Tolimir. The appeals chamber notes, however, that Mr. Tolimir's remaining convictions, in particular those for genocide committed through the killings of the men from Srebrenica and through the infliction of serious bodily or mental harm to the Bosnian Muslim population of Srebrenica, are sustained. In light of these genocide convictions alone, the appeals chamber considers that Tolimir's responsibility does not warrant a revision of his sentence. I will now read out the full text of the disposition of the appeals chamber judgment. Mr. Tolimir, would you stand, please? For the foregoing reasons, the appeals chamber, pursuant to Article 25 of the statute and the Rules 117 and 118 of the rules, noting the respective written submissions of the parties and the arguments they presented at the appeal hearing on 12 November 2014, sitting in open session, grants in part ground of appeal 6 and reverses Tolimir's conviction for extermination as a crime against humanity to the extent that it concerns the killings of the 3 Zepa leaders specified in paragraph 23.1 of the indictment. Grants in part, Judge Sekula and Judge Gune dissenting, ground of appeal 10, and reverses Tolimir's conviction for genocide committed through the causing of serious mental harm to the Bosnian Muslim population of eastern Bosnia and Herzegovina under Article 42b of the statute, to the extent that this conviction was based on the forcible transfer of Bosnian Muslims from Zepa. Grants in part ground of appeal 10 and reverses Tolimir's conviction for genocide through inflicting conditions of life calculated to destroy the Bosnian Muslim population of eastern Bosnia and Herzegovina under Article 42c of the statute. Grants ground of appeal 12 and reverses his conviction for genocide count 1 to the extent that it concerns the killings of the 3 Zepa leaders specified in paragraph 23.1 of the indictment. grants ground of appeal 20 and reverses Tolimir's conviction for genocide, count 1. Extermination is a crime against humanity, count 3. And murder as a violation of the laws or customs of war, count 5. To the extent they concern the killings of 6 Bosnian Muslim men near Trnovo, specified in paragraph 21:16 of the indictment. Dismisses. Judge Antonetti dissenting. Grounds of appeal 1, 3, 5, 7, 11, 13, 14, 15, 16, 17, 18, 19, 21, 22, 23, and 25. Dismisses Tolimir's remaining grounds of appeal. Affirms the remainder of Tolimir's convictions under counts 1, 2, 3, 5, 6, and 7. Affirms Tolimir's sentence of life imprisonment, subject to credit being given under Rule 101C of the rules for the period he has already spent in detention. Rules that this judgment shall be enforced immediately pursuant to Rule 118 of the rules. Orders that in accordance with Rule 103C and 107 of the rules, Tolimir is to remain in the custody of the tribunal pending the finalization of arrangements for his transfer to the state where he will serve his sentence. Judge William H. Sekule appends a partly dissenting opinion. Judge Mehmet Güney appends a partly dissenting opinion. Judge Jean-Claude Antonetti appends a separate and partly dissenting opinion. The hearing of the Appeals Chamber of the International Criminal Tribunal for the former Yugoslavia stands adjourned.
All rise, veuillez vous lever.